Now, we have for action H629, an act relating to access and to adoption records. The Committee on Judiciary has reported the bill favorably and with a proposal of amendment. Please listen to the second reading of the bill.
H629, act relating to access to adoption records.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? For this report, I'd like to recognize the reporter of the bill, Sen Sears Benton.
Thank you, Madam President. This bill is about adoption and adoptees and their access to birth records. It is a bill that builds on work that's been done in many other states, also the work done in the 1990s on adoption in Vermont, where at one point we were in the lead in terms of states with some of the best information available. But times have changed, and your Committee on Judiciary heard a lot of testimony, heard a lot of thoughts, but it's important to understand we're talking more about infant adoption, not teenagers adoption. But in this particular case, when it's an infant, it's called a triad. The triad are the birth parents, the adoptive parents, and the adoptee. Of that group, there is one person who did not sign on to that contract. That's the adoptee. So when we try to pass laws, and there were reasons for that, there is some resistance particularly from birth parents who didn't want to be known, who didn't want the information out there. So back in the 90s, when we were drafting our bill, we tried to craft legislation that recognized that fact. And in doing so, we didn't anticipate what would be happening in the year 2022. There's things like Ancestry.com, which makes it rather easy to find information. But that information comes in surprising ways. For example, one might find that they have another sister that they didn't know about, a brother they didn't know about, or that their father, but their father had two separate families that he was supporting. That information has come, and those are just people that are friends of mine who've gotten that information. So I can imagine the type of information that's out there. But this bill is really about access to the birth records, not about contact. There are sections that will hopefully allow the birth parents and the adoptee to have contact, but that's something that happens between the two parties. As I said earlier, I'll give you one example of an adoption. This one happened years ago. Child is named Stephen. He is placed with the petitioners, the adoptive family, in 1944 by a social worker. He had been in 3 different placements before this placement. The mother was an American Protestant faith, was sentenced to a women's reformatory for 2 years as a runaway and as a person who was beyond the control of her parents and others. The alleged father was an American of Italian extraction, fairly tall, dark brown eyes, black wavy hair, and according to the mother, good looking. That's the information about this child, Stephen. So Stephen is adopted by a family and grows up to be a state senator in Vermont. Who would have guessed? So I'm Stephen, Madam President. But my real name is Richard. But I was Stephen. So this bill, while it doesn't affect me because I was adopted in Massachusetts, has a great deal of meaning to me. I was one of the lucky ones. I got adopted by wonderful parents who raised me and helped me to become what I think is fairly successful over the years. But I've always wondered about my birth family. And it wasn't until I was in my late 50s, early 60s that I was able to find out anything. My birth mother had passed away. I still don't know anything about my alleged birth father. But I did find that I had a sister. And then later on, when I was talking with my sister that I didn't know I had, found out we have another sister, half-sister. Gosh, and that was through Ancestry.com. So that's what happens to adoptees in this life. We're getting more and more information through places we never expected to get it. So I was lucky. And maybe I can describe a little bit of what this bill does. And I really want to thank, there's a group of adoptees here who have been with this bill and worked very hard on it, have taken every step. And we would be joining most New England states with allowing access to your birth certificate. So as a summary of the bill, Vermont's current adoption laws were enacted 26 years ago with comprehensive legislation creating Title 15A. They've remained largely unchanged since that time. Current law provides a complex system regarding the release of non-identifying information. A summary of information found in the adoption record about the birth parents, both siblings, the adopted parents, and the adoptee's health, genetic and social background, obtained from the adoption registry. Identifying information, facts will help establish the identity, whereabouts of the adoptee, a birth parent or birth sibling, full name, date of birth, last known address, original birth certificates, all that information adoptee depends on the date of the adoption, with older adoptions less accessible. And whether the former parent filed I hate that term, by the way, former parent. Hopefully some legislature in the future will drop that. I have a former wife, but I don't have a former parent. I have a birth parent and my parents. So that's a horrible term, but that is what the law is. Has filed a request for non-disclosure with the adoption registry. And the reason we didn't change former parent in this bill is because it would take going through all the laws in the state to make that statutory change. And I believe at some point that will happen. The House Judiciary Amendment allows an adopted person who's 18 years of age or older to obtain a certified copy of the person's original birth certificate, regardless of whether the adoptee's former parent has consented to such disclosure. That's the huge change. If a former parent of an adoptee filed a request for non-disclosure of identifying information prior to July 1, 2023, request will be honored and the registry will not provide identifying information to the adoptee. However, this will not prevent the adoptee from obtaining a copy of their original birth certificate from the Department of Health. By the way, actually, there are very few people who put in they do not want to be contacted. It's really rare. To aid adoptees in determining whether to contact the former parent listed on their original birth certificate, the registry will develop a contract preference form that will indicate to the adoptee whether the former parent is amenable to being contacted by the adoptee, and may include information that the parent feels is important for the adoptee to know. When an adopted person seeks to obtain their original birth certificate, they will be advised that they may contact the registry to see if a contact preference form has been filed by the former parent. Starting no later than October 1, 2022, DCF, with the cooperation of other departments of state government, must initiate a campaign to make a reasonable effort to notify members of the public who may be affected by changes in statute governing the release of identifying and non-identifying information and access to the original birth certificate. Registry must also develop contract preferences forms and make some such forms readily available to the public by that date. The purpose, we're going to change the date, but the purpose by the House bill is 21 months of notice and an opportunity for persons to become aware of changes in access to adoption records. Section 1 of the bill is the purpose. Section 2 is a technical amendment. Section 3 eliminates the complex date-based system of release of records. Section 4 honors a previously filed request for non-disclosure identifying information, but does not prevent access to original birth record. Section 5 processes for obtaining the original birth record from the Department of Health and details contact preference form. Section 6 requires the state to engage in a public campaign about change to laws concerning release of adoption-related information. Section 7, technical amendment by striking language removed in Section 3. Section 8 requires DCF to initiate a public campaign, as I just mentioned. And Section 9, notice of requirements, and would have an effective date. The Judiciary Committee heard from a variety of individuals, including Jessica Barquist, Director of Policy and Organization at the Vermont Network Against Domestic and Sexual Violence, Carrie Brown, Executive Director of the Vermont Commission on Women, Sean Brown, the Commissioner of the Department of Children and Families, and Lori Canty, Director of Trial Court Operations, Claudia Corrigan Darcy, Impacted New York citizen, Becca Dragon, Vice President, People for Ethical Adoption Reform, Laurie Foster, Legislative Liaison and Vice President, American College of Nurse Midwives, Vermont affiliate, Jesse Hammond, Public Health Statistics Chief, Department of Health, Rebecca Henson, Impacted Citizen, New England Adoptee Rights Coalition, Ellie Lane, Impacted Citizen, New England Adoptee Rights Coalition, Gregory Luce, Attorney, Adoptee Rights Law Center. And I would say Gregory provided us with a lot of information about what other states are doing. And we were an outlier within our region in terms of access to birth records. And Christine Sumer, Adoption Registry Coordinator, Department of Children and Families, and Kate Van Wagner, the Lund Center, and Judge Thomas Zone, Chief Superior Judge from the Vermont Judiciary. The committee vote was 5-0-0, and we have some amendments that I'd like to present at this time, if that's okay, Madam President, excuse me. The amendments appear on page 2373. First is striking out the year 2024 and inserting in lieu of 2023. We just felt that adoptees shouldn't have to wait 2 years to get their records. Second is striking out subdivision 2 in its entirety and inserting in lieu thereof the following: a contact preference form shall include space where the parent may include information that the parent feels is important for the adoptee to know. A contact preference form may be withdrawn or revised at any time, and this was language that was worked out between the coalition supporting of adoptees as well as the network. While not everyone is completely satisfied, we think this is a good compromise and helps to provide that opportunity. Finally, the Third Amendment strikes out September and inserts October. That was for the forms by the Commissioner of the Department of Children and Families, who felt that September was just a little too quick to get the forms done and get the information out. And finally, the Fourth Amendment changes the effective date from 2024 to 2023. of the other sections of the bill. With that, Madam President, the Judiciary Committee would ask your support, the body's support of both the amendments and the bill as amended. Thank you.
Thank you, Senator. The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? All those in favor?
Aye.
All those opposed? The ayes have it, and you have adopted the amendments that shall be sent to the House.